So my name is Julie Gunnigle. I will be celebrating my 20th year being an attorney. It's been my pleasure over my career to handle high-profile marijuana cases, including the case of Lindsay Ridgell, which made its way through the Court of Appeals and is one of the first cases that we have in the country that affirms parental rights for folks who consume under the medical program. The firm Full Spectrum Law Collective is just that. It's a collective of cannabis and marijuana and hemp professionals all under the same roof who can do everything from family law related to consumption to helping people through complicated transactions to the impact litigation that we're engaged in right now. I got involved with HITA because I am a sucker for an underdog story, and that's what hemp has been at the Arizona Capitol for years. So I have been working alongside HITA to defeat some of the nastiest industry-ending bills that we have ever seen down at the Arizona legislature. But when this new case involving Chris Mays came up, how could one not get involved? You have an attorney general who is choosing to interpret the law in a way that does not align at all with what we know federally. And you have a group of professionals who are doing everything possible to follow the law. How could you not get involved? This is a David versus Goliath story. This is the story of a group of small business owners primarily who have been working to be compliant with federal law, who produce products that people want to consume. And as a result, they find themselves criminalized by the Attorney General's new and novel interpretation. What we find happening in Arizona is like what we have seen in other industries, not unlike newspaper, in fact, not unlike cannabis. What you have is a group of folks who have a lot of power and a lot of money who are using that power, money, and influence to put their competitors out of business. So a lot of folks have asked, who is on the receiving end of this Attorney General's opinion? Is it farmers? Is it producers? Is it retailers? Is it the consumers? And the answer to that question is yes. Everyone in the entire hemp supply chain is affected by what the Attorney General has chosen to do and how that office has chosen to interpret the Arizona Hemp Act. Farmers will not be able to sell the products because the market for the products evaporated nearly overnight. Brands who sell these products to wholesalers will not be able to sell them because, again, that market does not exist. Retailers who had these products on their shelves aren't buying from the producers and from the brands. Consumers, and I think it really is consumers who are going to bear the brunt of this particular decision, aren't going to be able to find these products, or the products that they do find will not be as safe and will not be as tested and will not be as regulated as what they encountered before. So winning this case is going to do something incredibly important for consumers and for everyone who is in the hemp supply chain. It will end this bogus argument that the Farm Bill is somehow a loophole in the law and will provide them the sort of legal credibility and authorization to continue on with their business. I think that what we will see once we have a court ruling, what we anticipate the court ruling will be and what we've asked for, is a declaration that industrial hemp in Arizona includes all of these potential goods and products that are being sold. And I think we're going to see a hemp renaissance. As soon as we have a court ruling that says that this is legal and emphatically so, I believe that we're going to see these retailers go back in business. I think we're going to see these folks who've been fired over the last few weeks hopefully get rehired. And I think we're going to see a resurgence all the way up to the top of the hemp supply chain. It's going to mean thousands of jobs, and it's going to mean hundreds of millions of dollars into the Arizona economy.